Welcome back to J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza. Today we're going to be discussing a New Jersey Supreme Court opinion just decided July 30th, 2025. This is the State of New Jersey versus Shawn Fenimore. This case does not affect the previous ruling in State versus LaDon Courtney. However, we are going to see that they reversed the appellate decision in a unanimous decision. In this case, an individual came to the New Jersey State Police headquarters and accused the defendant of harassment, including an allegation that he struck someone with his car while under the influence of drugs. A trooper called the defendant and requested he come to the Woodstown station to provide a statement with respect to the harassment allegation. The trooper told other officers, "I think the defendant's intoxicated, possibly. His voice is raspy and he's slurred his words." The defendant arrived at the station between 1 and 2 hours later. The trooper observed the defendant pull into the parking lot, exit the driver's side of the vehicle, and stumble almost into the station wall. Trooper brought the defendant into an interview room, read him his Miranda rights, and began speaking to him about the harassment complaint. That interview was not recorded. Trooper testified that he was slouched in his chair, his voice was slow and raspy, and his eyes were pinpoint. The trooper identified a fresh track mark on one of the defendant's arms and a white substance on the side of his mouth, which the trooper recognized as being signs of drug use. The trooper believed that the defendant was possibly under the influence of narcotics. When the defendant asked if he'd taken anything, he said he was just tired. The trooper didn't feel confident with the defendant leaving the station and conducted a series of field sobriety tests, specifically the HGN test, walk and turn test, and the one-leg stand test. The defendant failed the last two tests. The trooper arrested the defendant for driving while intoxicated, secures the defendant to a holding cell bench while he was barefoot, and informed him that the officers were going to conduct a probable cause search of his vehicle for intoxicants. The defendant was hysterical after his arrest, leading the trooper to believe that the defendant was afraid there was something in the car. The trooper's body-worn camera footage of the search was played at the suppression hearing. While the trooper and 4 other troopers were removing the co-defendant from the passenger seat of the vehicle, the trooper stated, "Here's the keys." Troopers located 4 folds of heroin and a needle in the center console and a gun loaded with 17 rounds of ammunition wrapped in a towel in a plastic bag on the back seat. The trooper stated, "There's a gun in here. I knew it." The search also uncovered 7 iPhones, 4 car keys for other cars, bolt cutters, and a tool used to break windows. After the search, Trooper spoke to the defendant in an interview room and reread him his Miranda rights, which the defendant waived. The second interview of the defendant occurred about 2 hours after his arrival and recorded on the trooper's body-worn camera. The defendant claimed ownership of 2 bags of heroin in the center console, but denied ownership of the other items. The defendant also admitted he used some heroin several hours before coming to the police station. The Appellate Division upheld the search, ruling that the police had probable cause to believe evidence of a crime was present in the defendant's vehicle, which arose spontaneously and unforeseeably, allowing police to conduct a warrantless on-scene search of the defendant's vehicle. In a unanimous decision, the New Jersey Supreme Court reversed and suppressed the evidence seized. Under the circumstances presented here, the automobile exception to the warrant requirement did not apply, and the police were required to obtain a warrant before searching the car. The defendant argues, among other things, that under the plain language of State v. Witt, New Jersey Supreme Court 2015, the automobile exception applies only if the car had been subject to a stop on the roadside. In this case, the defendant contends there was neither a stop nor a road. Instead, the defendant was at a location specifically exempted from the automobile exception in Witt, police headquarters. The defendant further argues that the Appellate Division's holding that Witt's use of the word headquarters actually meant a police impound lot was erroneous. In the defendant's view, there is no justification for a warrantless search of a car in the police station parking lot because a police station is a place where officers can ensure that they and any civilians are safe and that the car is secured before undertaking any search. The automobile exception to the warrant requirement under the New Jersey Constitution is significantly more protective of motorist privacy interests than its federal counterpart. New Jersey has imposed an extra requirement that the circumstances giving rise to probable cause be unforeseeable and spontaneous. This requirement is a reasonable accommodation of the competing interests between the individual's right to be free from unreasonable searches and law enforcement's investigatory demands. New Jersey also parts from federal jurisprudence that allows a police officer to conduct a warrantless search at headquarters merely because he could have done so on the side of the road. Whatever inherent exigency justifies a warrantless search at the scene under the automobile exception certainly cannot justify the failure to secure a warrant after towing and impounding a car at headquarters when it is practical to do so. New Jersey has identified several additional rationales that support a more limited automobile exception, including the risk of the loss or destruction of evidence. In the time that it takes for police to obtain a warrant, third persons could move or damage the car or remove or destroy evidence contained in it. 2. The unacceptable risk of serious bodily injury and death to officers, drivers, and passengers from prolonged encounters on the shoulder of a crowded highway. 3. The risk that motorists may feel compelled to consent to warrantless searches of their vehicles, which may be made on less than probable cause, either to avoid the dangers of protracted roadway stops or in the hope of escaping with only a warning rather than a traffic summons. 4. The recognition that, in certain circumstances, the privacy intrusion occasioned by a prompt search based on probable cause is not necessarily greater than a prolonged detention of the vehicle and its occupants while the police secure a warrant. And 5. The undue burden and impracticability of requiring police to post a special police detail to guard the immobilized automobile while pursuing a warrant. Under John's law, when a person has been arrested for a DWI offense, law enforcement shall impound the vehicle that the person was operating at the time of arrest. A vehicle impoundment pursuant to John's law shall be impounded for a period of 12 hours after the time of arrest or until such later time as the arrestee claiming the vehicle meets certain statutory requirements for release. Under the law, an impounded vehicle may be released to a person other than the arrestee prior to the end of the impoundment period only in specific, narrow circumstances. John's law makes no mention of searches and neither expressly authorizes nor expressly precludes a probable cause search of an impounded vehicle without a warrant. In addition, when the owner or permissive user is present, inventory searches of lawfully impounded vehicles are not permitted unless the owner or permissive user has been given the option of either consenting to the inventory or making its own arrangements for the safekeeping of property contained in the vehicle. There was no on-scene search here. The car was searched in a police barracks parking lot, not on the scene of a motor vehicle stop or any other incident. There was no other inherent exigency to justify a warrantless search under the automobile exception. Although defendant's car was in an unsecured parking lot prior to impoundment, the car was subject to a mandatory impoundment under John's law and therefore wasn't going anywhere for at least 12 hours. Before the search began, the defendant had been arrested for DWI and was secured barefoot to a holding cell bench. The car was in the police barracks parking lot. Police had the keys. The passenger, although not detained, had been escorted by a trooper to the police barracks. Therefore, police actually did have custody and control of the defendant's vehicle prior to the search, and the vehicle was not mobile. There was no risk of loss or destruction of evidence because there was no risk that the defendant or his passenger could move or damage the car or remove or destroy evidence contained in it while the defendant was detained and the passenger was inside the police barracks. There was no risk that third parties could move the car or remove or destroy evidence held within it. Police had the keys, and the car was parked at a State Police Barracks, visible to troopers through the windows in the lobby. The fact that the car was parked in a barracks parking lot, visible to officers inside the lobby, also defeats any possible burden or impracticability in a special police detail to guard the immobilized automobile. There was no risk of serious bodily injury and death to officers, defendant, or the passenger from an encounter on the shoulder of a crowded highway because there was no such encounter. There was also no risk that the defendant would feel compelled to consent to a warrantless search of the car, either to avoid the dangers of protracted roadway stops or in the hope of escaping with only a warning rather than a traffic summons. Witt's statement that the privacy intrusion occasioned by a prompt search based on probable cause is not necessarily greater than a prolonged detention of the vehicle and its occupants while the police secure a warrant cannot justify the failure to obtain a warrant in this case. The defendant already had been arrested and secured to a holding cell bench. The car was subject to a mandatory impoundment and wasn't going anywhere for at least 12 hours. 12 hours was certainly enough time to obtain a warrant. There is simply no evidence that securing a warrant would have delayed either the defendant's or the vehicle's detention. The only rationale possibly remaining would have been the reduced expectation of privacy based on the pervasive regulation of vehicles capable of traveling on the public highways. On its own, this rationale has never justified the warrantless search of a car. In this case, when the car was parked in a State Police Barracks parking lot, police had arrested the driver, removed the passenger, and obtained the keys, and the car was subject to imminent mandatory impoundment. The automobile exception to the warrant requirement did not apply. The police were therefore required to obtain a warrant before searching the vehicle. In this unanimous decision by the New Jersey Supreme Court, they further strengthened their previous stances about the New Jersey Constitution, Article 1, Paragraph 7, and how we are more restrictive than our federal counterparts when it comes to the Carroll Doctrine and the inherent mobility of a vehicle with respect to warrantless searches. When in doubt, contact your prosecutor, get a search warrant. If the vehicle's secured somewhere, if the defendant's already secured, if you feel that the exigency aspects are already abated in your case, get a warrant. The issue here was not the probable cause. The issue was here about the fact that they did not get a warrant. You're better off taking those extra steps up front, shifting the burden onto the defendant to show that there was something factually deficient inside of your search warrant, rather than later having to go through these suppression hearings. The result of this case is that the defendant had the evidence suppressed with respect to not only heroin, but an illegal firearm. And our goal is to obviously get these types of convictions. Until next time, stay safe and subscribe for more updates.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free, only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.